Good afternoon, everyone, and thank you for joining us. I have the distinct pleasure of introducing Lee Hornberger. Lee is a former chair of the Alternative Dispute Resolution Section, editor emeritus of the Michigan Dispute Resolution Journal, former president of Grand Traverse Leelanau Antrim Bar Association, and former chair of Traverse City Human Rights Commission. He is a member of the Professional Resolution Experts of Michigan and a diplomate member of the National Academy of Distinguished Neutrals. He has received the ADR Section's Distinguished Service Award and George Bashara Award. Help me introduce my friend and colleague, Lee Hornberger. Thank you.
Thank you, Alex, for the nice introduction. I appreciate that. And let's go to slide 2. We're going to be discussing Michigan mediation and arbitration case law update since September of 2022. Once in a while, I'll say MSA. MSA is mediated settlement agreement. This will be more fun for you if you put your typed or printed materials away, get a note piece of paper with a pen if you wish, but this is going to be much more fun if you just sit back and listen. We're going to be covering a number of cases. Among those cases, there's at least 4 important cases. One of these is McMillan versus City of Kalamazoo, which involves contractual limitations period for either suing or for bringing an arbitration matter where the limitations period is in the job application. The second very important case is Michigan ASME Council 25 versus Wayne County. In that case, the issue is the standard of review for a public labor arbitration award. Is it the enterprise standard for labor arbitration, or is it the commercial arbitration standard from the Gavin decision? The third important case is GoJet Airlines, which is where the Michigan Supreme Court has asked for briefing and oral argument on whether or not a pre-dispute mandatory arbitration of Civil Rights Act claims is illegal because of public policy. In addition, Riemann versus Riemann, where the Michigan Supreme Court enforced an oral settlement agreement concerning the distribution of income flow from some real estate. Let's go to mediation first, and let's do some Supreme Court activity concerning mediation. The first of these is the Riemann versus Riemann decision. In Riemann, the Supreme Court reversed that part of a Court of Appeals decision which had found that the plaintiff's claims were barred by the statute of frauds. The alleged oral settlement agreement addressed profits from sale proceeds from real estate transactions, as opposed to creating or transferring an interest in the real estate. The Supreme Court remanded the case for consideration of whether a question of fact existed as to whether the parties had a post-sale oral settlement agreement. Justices Viviano and Zayo dissented. They agreed in their dissent with the Court of Appeals that the statute of frauds barred the plaintiff's claim that the oral agreement and not the parties' executed written document reflected the parties' settlement agreement. In Citizens Insurance Company versus Livingston County Road Commission, the Supreme Court ordered oral argument. In this case, and this is an important case if you're involved with activity concerning Michigan local governments. In Citizens Insurance, the Court of Appeals held that a local government can be bound by a settlement agreement entered into by its attorney if the government later ratifies the agreement, or two, the attorney had prior special authority to settle the claim. The attorney may bind the client to the settlement agreement according to the Court of Appeals if the attorney had some precedent special authority to enter into the agreement on behalf of the client, even if the client is a governmental unit. In this case, there was ongoing discovery going on related to whether the commission attorney had authority from the commission to settle the case on its behalf. Notwithstanding that there would be no public meeting ratifying the agreement, the commission, according to the Court of Appeals, would be bound by the settlement agreement. In March of this year, the Supreme Court ordered oral argument on the application. The oral argument in this case and other cases has not been held yet. The briefs will address, number one, whether there was a material question of fact regarding whether the parties had entered into a binding agreement. Second, whether there was a material question of fact regarding whether the defendant's former attorney had authority to approve the settlement agreement. And third, whether the defendant governmental entity waived the attorney-client privilege as to documents related to its former attorney's authority to settle. This could become and is an important case. Let's go to Michigan Court of Appeals published decisions. The first is Brendel versus Morris. This is literally the $100,000 case where the Court of Appeals affirmed a circuit court modification of a consent judgment of divorce. The circuit court is permitted to modify child support orders when changed circumstances demand, even if the child support award was negotiated as part of a consent judgment of divorce. The parties agreed to a one-time lump sum $100,000 child support payment in the consent JOD. Before the payment could be made, the recipient husband stopped exercising most of his parenting time. According to the circuit court and approved by the Court of Appeals, this change of circumstances warranted a re-review of child support, and the payment requirements for child support, and when the father stopped the parenting time, he discontinued the requirement for him to get the $100,000. So the basic lesson of Brendel is, if you're the father who's going to get a $100,000 check for child support, continue to exercise your child support time, at least until you get the check from the mother and the check clears. Let's go to Michigan Court of Appeals on published decisions concerning mediation. In Deep Harbor Condominium Association versus Marine Adventure, the attorneys exchanged emails concerning a potential settlement agreement. And emails went back and forth, and ultimately one party claimed that the emails represented a settlement agreement enforceable under MCR 2.50CG, the terms of which included a global release of all claims by all the parties. The other parties opposed the motion to enforce the settlement agreement. They contended the emails were mere negotiations. The circuit court granted the motion to enforce the settlement agreement. The circuit court said the settlement agreement was proposed by one party and accepted by the other attorneys on behalf of their clients. But the circuit court did not enter a settlement agreement because the parties had not agreed to specific terms to include in the settlement agreement. This gets even better, folks. The circuit court ordered the parties to submit proposed settlement documents, and the circuit court would then hold a hearing to determine what the specific terms were for the settlement agreement that the circuit court was enforcing. The appellants contended the emails did not show a meeting of the minds on all essential terms. The Court of Appeals agreed with the appellants. The Court of Appeals indicated that no agreement was set forth on the record in open court. The emails conform contract compliance in accordance with 2.507G, provided they show a meeting of minds. When the email chain is purported to reflect a settlement agreement, the emails must contain indisputable proof that the emails were a final settlement agreement of the parties and the terms on which the parties settled. In the Talawanda Trust case, after mediation, the parties consented to the mediator making a proposal for resolution of all the remaining issues. And that proposal became the settlement agreement. Ultimately, the appellants argued that the mediator lacked authority to make a binding post-mediation ruling. This was after, prior to a closing, the parties had emailed the mediator asking as to who would be responsible for certain costs. The mediator provided a response. The Court of Appeals did not address whether the mediator's interpretation of the settlement agreement was binding, because the settlement agreement is subject to de novo review, and the Court of Appeals agreed with the mediator's interpretation, not because it was the mediator's interpretation, but because the Court of Appeals basically agreed with it. In the estate of Gajibik, we have a probate situation where we have some survivors and we have a settlement. And ultimately, what happened is the attorney for one of the parties signed the settlement agreement, but the party himself did not sign the settlement agreement. And the Court of Appeals and the Circuit Court ruled that the party doesn't have to sign the settlement agreement, that under MCR 2.507G, the attorney's signature is fine. Almost exactly the same thing happened in the next case, which is divorce versus Sims. In this divorce case, the plaintiff appealed the Circuit Court judgment of divorce. The Court of Appeals held that the Circuit Court abused its discretion by failing to enter a signed judgment of divorce as it was written and instead changed it. The Circuit Court said, the Court of Appeals said the Circuit Court did not have that authority. We're now going to slide 5. Slide 5. This is another signature issue. In International Union Security Police and Fire Professionals case, the Circuit Court determined that the lack of the plaintiff's signature on the settlement agreement was not dispositive, because the stipulated order to which the settlement agreement was attached was signed by the attorneys, and the order referenced that the parties had entered into a settlement agreement. The Court of Appeals held it was reasonable to conclude that the stipulated order was logically associated with the settlement agreement, and one signature on the order was basically the same as signing the attached settlement document. In McNay versus McNay, we had a long-term marriage. That resulted in a divorce action, which led to mediation, arbitration, and a consent judgment of divorce. The parties agreed that the following, this is a quote more or less, the following issues will be submitted to arbitration in lieu of court trial. Basically, everything would go to arbitration, end quote. The arbitrator issued an opinion regarding the judgment of divorce. The defendant moved to modify that section of the JOD. The circuit court denied the defendant's motion. The Court of Appeals affirmed. The Court of Appeals held that any ambiguity surrounding how the defendant was supposed to pay plaintiff for her interest in the house was within the arbitrator's authority. And the arbitrator had the authority to resolve that issue. So McNay versus May is an example of, number one, the authority of the arbitrator, but importantly, number two, how important the wording is, both in DRAA arbitration and regular arbitration, on the agreement to arbitrate language. Let's go to estate of Terry Bremer. In the Terry Bremer estate, Terry Bremer dies, and there's a lot of heirs, there's a lot of interested parties, and ultimately there's a mediation. Luckily, the fiduciary sent out a notice before the mediation that said, I'm the fiduciary and we're going to have the mediation, and you got to come to the mediation. And if you don't, to the degree that I, the fiduciary, agree to the settlement, you're bound by it. One of the interested parties did not show up for the mediation and then contested the settlement. And the Court of Appeals affirmed the probate court entering an order denying the appellant's objection. This was because of MCR 5.120, which says if you're the fiduciary and you give notice to all the interested parties, you can bind them to stuff. So the Bremer case is important, especially if you're doing probate mediation, because it reminds us of MCR 5.120. In Keeson versus Keeson, we have another dissolved marriage. And there was a judgment of divorce, and there was an issue of how to interpret the judgment of divorce. And the Court of Appeals affirmed the entry of the consent judgment of divorce. Moore versus Bush involves attorney fees in a settlement agreement. The circuit court declined to enter attorney fees as arguably required by the settlement agreement. The Court of Appeals reversed the circuit court order denying attorney fees and remanded for further proceedings. So Moore versus Bush is a reminder that under Michigan law, parties may contract for payment of attorney fees. Townsend versus Esters is an interesting case. At a hearing on a motion, the plaintiff's counsel in front of the judge indicated that although his client, the plaintiff, would not agree to sign the agreement, the plaintiff had authorized their counsel to sign the agreement. And the circuit court, with the Court of Appeals agreeing, said that because plaintiff did not challenge the validity of the settlement agreement and the agreement was valid, and the plaintiff had voluntarily relinquished the plaintiff's right to a jury trial. We're now going to slide 6. We're segueing into arbitration, and there's some fun stuff here. Let's go to McMillan versus City of Kalamazoo. In McMillan, the plaintiff, McMillan, applied for a job with the City of Kalamazoo in 2004. She completed the job application and underwent testing and a background check, but she did not get the job. In 2005, the city contacted her about the job as a public safety officer, and she was hired. She did not fill out another application. In 2019, the plaintiff sued the city, alleging discrimination in violation of civil rights acts. The city moved for summary disposition, relying on the provision in the application plaintiff had signed in 2004 that had a 9-month limitations period. The circuit court granted the city's motion for summary disposition. The Court of Appeals affirmed. The circuit court ordered argument on a number of issues. Number one, did Timco versus Oakwood Custom Coating correctly hold that limitations issues in the job application are part of a binding employment contract? Number two, is the employee bound by the terms of a document that say this is not a contract of employment? And number three, this issue keeps raising itself, whether the contractual limitation clauses that restrict civil rights claims violate public policy. After hearing oral argument on the application, the Supreme Court reversed that part of the Court of Appeals judgment affirming summary disposition for defendant based on the shortened 9 months limitation period. And the Supreme Court remanded the case to the Circuit Court for further proceedings. The Circuit Court and the Court of Appeals held that the lawsuit was barred by the 9-month limitation period. The Supreme Court held that there was a genuine issue of material fact, whether the plaintiff had notice of the use of the prior application and whether she agreed to be bound by those materials. According to the Supreme Court, the city had not sufficiently demonstrated that the parties had a mutuality of agreement to be entitled to summary disposition on the 9-month limitation language. Justice Welch, concurring, would have ruled on whether Timco correctly held that limitation clauses in job applications are part of a binding employment contract. The ultimate Supreme Court order did not mention the other reasons it had asked for oral argument. It didn't mention not a contract of employment request for oral argument, and it did not mention not violate public policy request for oral argument. The next case, at least for those doing labor law, is probably the most important case we'll discuss today. And that's Michigan AFSCME Council 25 versus Wayne County. In a split decision, the Court of Appeals affirmed the Circuit Court vacatur of a labor arbitration award. On the verge of discharge, the employee took a cash-in retirement. The employee applied for retirement while awaiting outcome of a disciplinary action. The retirement application required him to agree to a separation waiver. The waiver stated, which he signed, the waiver stated he was terminating his employment and not seeking reemployment. The defendant terminated his employment the following day. The employee then allowed his retirement application to proceed, but he also filed a grievance pursuant to the collective bargaining agreement with the employer seeking reinstatement. The county retirement system approved the employee's retirement. The employee then took a wad of money from the county retirement system and transferred it to his private IRA. Around 8 months later, in a 70-page decision, the arbitrator reinstated the employee in light of the background retirement issues and the so-called waiver document issue. The Circuit Court and the Court of Appeals vacated the reinstatement award in light of the IRS issues. There was vigorous oral argument before the Court of Appeals. Judge Jansen dissented. Judge Jansen's dissent stated that the arbitrator did not exceed its authority in issuing the award, and the Circuit Court should have confirmed the award. According to the dissent, the applicability of defenses to arbitration, including waiver, are for the arbitrator to decide. The only two issues before the arbitrator were whether the employee was terminated for just cause, and if not, what should be the remedy. According to the dissent, the separation waiver was raised before the arbitrator as a defense. The employer's argument that the award was illegal or violated public policy because of possible tax code violations was irrelevant. In September of this year, the Supreme Court ordered oral argument on the application. The parties were told to brief, and have briefed, and there's some serious friend of the court briefing here, on whether the standard in Detroit Auto Insurance Exchange versus Gavin is the standard that the Court of Appeals and the Circuit Court should have used. The Court of Appeals used the Gavin commercial arbitration case standard. The argument in favor of the arbitration award that the Supreme Court will have to decide is whether the trilogy cases that specifically talk about labor arbitration should have been followed. And we're still waiting for the oral argument before the Supreme Court to be scheduled. Let's segue to another case, and let's go to GoJet Airlines. GoJet Airlines is another case where the Supreme Court has ordered oral argument and supplemental briefing on the leave for application to appeal. In GoJet Airlines, the plaintiff brought claims against his employer and supervisor under the Elliott Lawson Civil Rights Act, alleging discrimination. The defendants requested summary disposition, citing that the employment agreement that had been signed by the plaintiff in his application for the position. The agreement stated that the plaintiff and the employer agreed to resolve all claims arising out of the application, the employment, and any termination exclusively by arbitration. The Circuit Court denied the motion for summary disposition as to the Civil Rights Act claims. The Court of Appeals reversed the holding that the Circuit Court erred by determining whether the Civil Rights Act claims were subject to arbitration. On June of this year, the Supreme Court ordered oral argument on the issue of whether the civil rights discrimination claims may be subject to mandatory arbitration as a condition of Michigan law. So we're going back here to what was partially looked at in the Lishon case and in other cases. There's also an issue lurking in the background that what impact, if any, does the Federal Arbitration Act have on the issue of whether or not Michigan law can allow or not allow mandatory pre-dispute arbitration of statutory dispute civil rights claims. We're going to slide 7 now, slide 7. In Kilpatrick versus Lansing Community College, the Court of Appeals affirmed the Circuit Court ruling that the arbitrators lack jurisdiction over claims to which the state legislature has granted exclusive jurisdiction to administrative agencies. According to the Court of Appeals in this published decision, because the Wage and Fringe Benefits Act grants exclusive jurisdiction to the Michigan Department of Labor for all wage and fringe benefit claims, the arbitrator was without jurisdiction to consider the plaintiff's fringe benefit claims. Stewart versus School District of City of Flint kind of takes us back to the Altobelli versus Hartman Michigan Supreme Court case 499-284 on whether or not an agreement to arbitrate picks up the individual employer defendants. In Stewart, the plaintiff was hired by the defendants to be the superintendent of schools for the city of Flint. She worked under a written agreement that had a broad arbitration clause for resolution of disputes. The signatories to the contract were the individual plaintiff and, quote, the Board of Education and the school district of the city of Flint, end quote. The plaintiff, causing her ultimate demise, clashed with several members of the Board of Education, including the defendant board members. The plaintiff complained that the board members created a hostile work environment. This dispute resulted in plaintiff's removal. After the plaintiff filed a lawsuit against the board members and the board, they moved for summary disposition based on the contractual arbitration provision. The Circuit Court granted relief to all entity defendants, the Board of Education, but not the individual board members because they were not parties to the employment agreement that contained the arbitration provision. The Court of Appeals in this published decision reversed the denial of summary disposition because the obligation to arbitrate disputes extended to the individual board members as well as the school district. The Court of Appeals ruled that the Circuit Court erred in denying the board members the ability to demand arbitration under the employment agreement between plaintiff and the district. Let's go to Legacy Custom Builders versus Rogers. In the Rogers case, the plaintiff appealed a circuit court order compelling arbitration. The Court of Appeals held that the circuit court correctly enforced the agreement to arbitrate. But importantly for what we're doing here today, the Court of Appeals held that the circuit court should have stayed the circuit court proceedings pending the arbitration instead of dismissing the case. And that would be because if 691.16877, which says that if the circuit court grants the motion to arbitrate, they should stay the pending case while the arbitration's going on. There's been some non-published cases that say this, but I think Rogers is the first one that says that 691.1687 means what it says. Let's go to slide 8, please. Slide 8. Kalamazoo Public Schools versus Kalamazoo Education Association concern the definition of the word teacher in the Public Employment Relations Act. This involved a guidance counselor. If the guidance counselor was a teacher, the union, the way the law was then written, could not arbitrate the transfer of a teacher. But if the guidance counselor was not a teacher, then the union could arbitrate under the Public Employment Relations Act the transfer of the guidance counselor. In a split decision, the Court of Appeals held that the definition of teacher under the Public Employment Relations Act is not a dictionary definition, but rather is the definition of teacher in the Teacher Tenure Act, and that the Michigan Employment Relations Commission had erred by disregarding both of these statutory definitions. The Court of Appeal agreed with the employer that the Teacher Tenure Act definition of teacher was controlling, and therefore the guidance counselor was a teacher, which was not good for the guidance counselor in this situation. Judge Yates dissented. Judge Yates stated that the Court of Appeals should have given deference to, should have accepted the Michigan Employment Relations Commission ruling that the employee as a guidance counselor was not a teacher for purposes of placement under the Public Employment Relations Act. This even gets better now, folks. In Payne versus Godzilla, the whole case boils down to what does the word and mean? A-N-D, quote, and. This involved a contract non-compete case between different dentists. And the agreement to arbitrate in this case said, what can go to arbitration is any dispute between the employee and the employer concerning questions of fact arising under this agreement and concerning issues related to wrongful termination. The circuit court and the Court of Appeals held that and meant that both questions of fact would have to be an issue to require arbitration. That if the only issue was wrongful termination, but it didn't arise under the agreement, then there could be no arbitration. And therefore, in this case, there would be no arbitration. I don't know what the parties were really thinking when they used and, but again, Payne versus Godzilla tells us with a vengeance how every word in the agreement to mediate is important and can have what some people might think are unintended consequences. We have another AFSCME Council 25 case. This is a different AFSCME Council. Well, it's the same AFSCME Council, but it's a different case. In AFSCME Council 25, Local 1690 versus Wayne County Airport Authority, the airport case. The collective bargaining agreement at one place said that if you bring someone into a department who makes more money than the people who are already there, the people who are already in that department will get a wage increase to bring them up to what the new hire person gets. But In the arbitrator jurisdiction paragraph of the contract, the CBA said, under no circumstances ever can the arbitrator grant a wage increase. And so this is before the arbitrator, and the arbitrator basically said, even though it violates the contract for this higher wage person to be brought in and these other people not to get a wage increase, I, the arbitrator, do not have the authority to do a wage increase. The union said, well, that's not appropriate, and they went to circuit court for vacatur. The circuit court denied the vacatur, and the Court of Appeals affirmed. In Zora versus A&M, we have an example. It's kind of complicated on how Lyshon versus Morse pops up. Zora is also an example of how different kinds of arbitration can have different standards of review. There's DRAA review, there's the labor arbitration review, there's the Gavin commercial arbitration review. So in Zora, the circuit court, in issuing a pro-arbitration decision, used the word arguably. And the losing party said, well, arguably goes with another standard of review. And the Court of Appeals indicated that the circuit court ruling was not predicated with the parties' dispute merely being arguably within the arbitration clause. Weaver versus Weaver is a domestic relations arbitration case. The defendant wife argued that the circuit court erred by entering a judgment of divorce that did not appropriately split the property. The circuit court and the Court of Appeals said it's the job of the arbitrator to split the property, and the reviewing court may not review the arbitrator's finding of fact, and any error of law must be discernible on the face of the award. In Lexell versus Intrust Building, the issue involved the apportionment of liquidated damages. And the Court of Appeals affirmed the confirmation of an award in which liquidated damages were apportioned. Certainty versus Davis is another example of the power that the arbitrator has under appropriate circumstances of granting an attorney fee award. The Court of Appeals held that the circuit court erred by vacating an attorney fee award. We're going to slide 10. Slide 10. Slide 10. In slide 10, we have UAW versus 55th Circuit. In this case, the employer argued that the union did not properly or timely request arbitration under the collective bargaining agreement. And therefore, the employer argued the matter was withdrawn and the case was no longer honorable, and there was no reason to go to arbitration for any reason. And the employer argued that the collective bargaining agreement provides that the threshold issue of whether the union's request for arbitration was timely was for the court rather than the arbitrator. The circuit court and the Court of Appeals gave short thrift to this argument. The circuit court and the Court of Appeals held that the threshold issues of whether the employer timely invoked arbitration under the collective bargaining agreement is to be decided by the arbitrator and not by the court. Payne Charlie versus Team Wellness involved an employment agreement arbitration. The defendant appealed the circuit court conclusion that the employment agreement did not require the parties to arbitrate. According to the defendant, the parties were required to resolve the dispute in arbitration under the plain terms of the employment agreement. The Court of Appeals agreed and reversed the circuit court.
Lee,
Yes.
you've asked me to give you a 3-minute warning.
3-minute warning, 30 seconds.
Thank you.
Slide 11. Shango. In Shango, the defendant claimed he had not read the arbitration agreement and therefore he could not waive the arbitration agreement. And the Court of Appeals said you don't have to read the arbitration agreement to be bound by the arbitration agreement. In conclusion, as we've seen, we have 4 important cases lurking around or coming to us from the Supreme Court. We have McMillan versus City of Kalamazoo involving limitations periods and job applications. We have Michigan AFSCME Council 25 versus Wayne County, which involves the standard for review of a labor arbitration decision. We have GoJet Airlines, where the issue of mandatory pre-dispute arbitration of statutory discriminatory claims continues to surface. And we have the interesting case of Riemann versus Riemann, where the Supreme Court enforced an oral settlement agreement distribution of income. Thank you and good afternoon.
Thank you, Lee, for that comprehensive presentation. We are looking at the Q&A, and Professor Aaron Archer from University of Detroit Mercy School of Law, thanks you for compiling all of this great ADR information each year. I don't see any other questions. Oh, great presentation from Betty Widgeon. And we're 1 minute before time, so lots of Robert Johansson, Sheldon Larkey, Lisa Timmons, Kathy Beatty have all complimented the presentation. I'm not sure if there's a chat, okay, issue, but you can visit the ADR annual conference website for these materials. Thank you so much, everyone.